The answer is despite the cessation of operation by a healthcare provider or the termination of practice of an independent healthcare professional, while the complaint is being heard, the proceeding shall continue until the resolution of the case. And that ends my presentation for the offenses and penalties under the Republic Act 7875 as amended. Thank you for watching. See you in the next one. Peace out.
Today I'll be discussing Title 10 and Title 11 of the Republic Act 7875 as amended by Republic Act 9241 and Article 10606. So let me start with the administrative remedies of healthcare providers and members. The Rule 1 on common provisions is covered by Section 189 to 190. So let me begin with the jurisdiction. So the corporation, through the Grievance and Appeals Review Committee or the GARCI in the board, shall hear and decide all grievances filed by any accredited healthcare provider or by any member or a dependent against any program implementer. So the corporation shall likewise act on all protests against administrative decisions involving payment of charges, fees, or claims subject to the procedures hereafter provided. So what are the grievance or protests not covered in this rule? So the administrative or criminal complaint or charge under the jurisdiction of the Office of the Ombudsman, Sandigan Bayan, Civil Service Commission, or the regular courts of justice are not covered by these rules and shall be dealt with in accordance with applicable laws. Now let me proceed with the grievance against program implementers, which is covered by Section 191 to 195. So what are the grounds of grievances? So the grounds of grievances are as follows: any violation of the rights of patients, willful neglect of duty resulting in loss or non-availment of benefits by members or their dependents, unjustifiable delay in actions on claims, delay in the processing of claims that extends beyond the prescribed period, and any other act or omission that tends to undermine or defeat the purpose of the act and this rule. Who may file then with the grievance complaint with the corporation? So as amended by Republic Act 10606, a member, a dependent, or a healthcare provider may file a complaint for grievance. Now, where will this member, dependent, or healthcare provider file their complaint? So a grievance covered by the rule may be filed with the Philhealth office where the aggrieved healthcare provider is located or where the member resides. So what are the contents of this grievance or the complaint? So all complaints for grievance shall contain, among others, the following: the name or names and address or addresses of the aggrieved party or parties, the name or names and address or addresses of respondent, program implementer or implementors, a clear and concise statement of the aggrieved party cause or causes of action, citing the specific ground relied upon and acts of omission complaint of which constitute the same and the relief sought. So the complaint shall be verified and accompanied by the affidavits of the complaint and the witnesses, as well as other supporting documents in such number of copies as there are respondents, plus 2 copies for the official file. So where is this grievance being referred to? By the Philhealth office. So upon receipt by the Philhealth office of a grievance complaint, it shall refer the same to the Grievance and Appeals Review Committee or the GARC within 5 calendar days. Now we proceed with Rule 3 or the Grievance and Appeals Review Committee, which covers section 196 to 206. So what is the composition of this GARC or the Grievance and Appeals Review Committee? So as amended by Republic Act 10606, the board shall create a Grievance and Appeal Review Committee composed of 5 members, herein referred to as the committee, which, subject to the procedures enumerated, shall receive and recommend appropriate action on complaints from members, healthcare providers relative to this act and its implementing rules and regulation. So the committee shall have as one of its members a representative of any of the accredited healthcare providers as endorsed by the DOH. So what constitutes a quorum, or what are the votes required to deliberate on the grievance brought before the committee? So 5 members of the GARC shall constitute a quorum to deliberate on and decide any grievance before it. So in all cases, the concurrence of at least 5 members of the GARC, which shall include the president as the presiding officer, shall be necessary to reach a decision, resolution, order, or ruling. Now we go to the preliminary determination. So upon the endorsement of the grievance, so the GARC, after consideration of the allegation thereof, may dismiss a case outright due to lack of verification, failure to state a cause of action, or any valid ground for the dismissal of the grievance, or proceed to hear and determine the case. Now, if the GARC decides to proceed to hear and determine the case, the respondent implementer shall be required to file a verified or counter affidavit with supporting documents within 5 calendar days from the service of summons. Will there be a judgment by default? The answer is yes. Should the respondent implementer fail to answer within the reglementary 5 calendar day period, the GARC, motu proprio or upon motion of the aggrieved party, shall render judgment as may be warranted by the facts on record and limited to what is prayed for in the complaint for grievance. Now, after an answer is filed and the issues are joined, the GARC shall require the parties to submit within 10 calendar days from receipt of the order a brief statement of the respective positions, setting forth the law and the facts relied upon by them. Now, in the event the GARC finds upon consideration of the pleadings, the records or the proceeding before the corporation and the position paper submitted by the parties, that a judgment may be rendered thereon without need of a formal hearing. It may proceed to render judgment not later than 10 calendar days from the submission of the position papers by the parties. Can the GARC conduct clarificatory hearing? So the GARC can. So in cases where the GARC deems it necessary to hold a hearing to clarify specific factual matters before rendering judgment, it shall set the case for hearing for said purpose. At such hearing, Witnesses whose affidavits were previously submitted may be asked clarificatory questions by the proponent and by the Garci, and may be cross-examined by the adverse party. So the order setting the case for hearing shall specify the witnesses who will be called to testify and the matters on which their examination will deal. So the hearing shall be terminated within 15 days, and the case shall decide by the Garci within 15 calendar days from such termination. Now we go to the contents of the decision. So what are the content of the decision? So the decision of the Garci shall be clear and concise and shall include brief statements of the fact of the case, the issues involved, the applicable laws or rules, conclusion and reasons therefore, and the specific reliefs granted. So when does the decision of Garci becomes final and executory? So the decision of the Garci shall become final and executory unless an appeal is filed with the board within 30 days from receipt of the resolution as amended by Republic Act 10606. So what are the administrative sanctions to the respondent implementor? So upon finding of guilt, the Garci may censure, reprimand, or suspend the respondent implementor from office depending on the gravity of the offense, provided that the suspension shall not exceed 30 days. But bear in mind that in all proceedings, the Garci and the board shall not be bound by the technical rules of evidence, provided, however, that the rules of court shall apply with suppletory effect. Now, what are the powers of Garci? Under Section 206, the Garci can administer oaths, certify to official acts and issue subpoena ad testificandum to compel the attendance and testimony of witness, and subpoena ducis tecum to enjoin the production of books, papers, and other records pertinent to the case. So any act of contumacy shall be dealt with in accordance with Section 14, Chapter 3, Book 7 of the Revised Administrative Code. Now we go to Rule 4. And Rule 4 talks about the review of Garci decision, which is covered by Sections 207 to 210. So the board and bank shall have exclusive appellate jurisdiction to review the decision of the Garci in grievances filed under Republic Act 78-75 as amended and by this rule. So when to file petition for review with the board? So a petition for review may be filed with the board within a non-extendable period of 30 calendar days from the receipt of the decision of the Garci. And who may file the petition for review? So any of the parties in a complaint for grievance decided by the Garci may file a petition for review. The board shall resolve the petition within 30 calendar days from receipt thereof with the records of the case. So that ends my report. Thank you.